Hello, everyone, and welcome to Beyond Wills and Trust, how to safeguard your wealth and peace of mind. We have packed the next half hour with information that you won't be able to find anywhere else online because it comes from real world experience building estate plans at the absolute highest level. But first, I want to talk to you. If you're watching this presentation, you most likely own your own home. You're retired or considering retirement soon, and you've done well enough in life to the point where you have some money to take you through all that. You've done the right thing your whole life. You've gotten everything in order for the most part. You did the best you could in your career. You took care of your family and you saved what money you could along the way. But there's an elephant in the room that we need to discuss and address. What's going to happen when something out of your control takes you off that plan? And for the most part, I'm not talking about death. You probably have your health in order, aren't worried about that anytime soon, and healthcare in this country is better than ever, even if more expensive. I'm talking about what happens before that. The accidental fall playing tennis that sends someone to the hospital. When forgetting the right word to use starts to become forgetting what day it is. Things that happen to all of us sooner or later. And the unfortunate fact is, 7 out of 10 people have no plan in place for that. I won't judge you if you're one of them, because legal professionals as a whole have been doing a worse and worse job of educating people on how this can affect them. Let me go ahead and switch to my slides. So that brings us to why I'm holding this presentation today. According to Merrill Lynch, $84 trillion is going to be passed down in inheritance from baby boomers and the silent generation between now and 2045. It's the single largest wealth transfer in history, and it's happening everywhere around you, whether you realize it or not. As an estate planning professional, I can tell you what happens when inheritance goes badly. Fighting over assets, taking a 30% haircut from unnecessary taxes, money and houses going to spouses who have been out of the picture for decades. But when you have the knowledge to set things up the right way, a few hours of effort can completely change the trajectory of a family. This isn't just about money or taxes or legal documents. This is about legacy. We work hard our entire lives to take care of our needs and get ahead. And after we're taken care of, we can take care of others. For most of the people we work with, that's family. But that can also be friends, charities, or even pets in some instances. Getting your affairs in order is one of the most noble things a person can do because it's the work that will take care of what you care about after you're gone. And at the end of the day, that's what this is all about. The strategies we're going to be going over today are the same strategies that attorneys at our partner firms are using to protect families with well over $10 million in net worth. We've used these with over 4,000 families all across the country in the last few decades. But for the first time ever, we're sharing that information with you. Whether your part of the wealth transfer is $10 million or $100,000, I want you to have the tools to make sure things go your way and not the way of a court. You and every person watching this presentation represents an American family. We're not going to solve the $84 trillion challenge ourselves, but everyone that takes the knowledge in this presentation and acts on it is going to be making a huge difference for their own family. After this presentation, you'll walk away with how to shield your assets from unnecessary inheritance taxes, so your family keeps more of what you built. And by the way, you'll avoid the 10-year liquidation penalty from recent legislation. Why trusts, not wills, are the real game changer when it comes to avoiding probate court, plus how our proven funding strategy ensures every asset gets protected without legal loopholes. The cost of leaving your legacy unprotected. How families lose up to 30% of their inheritance to taxes and predators like gold-digging partners. But with this strategy, your assets are secured no matter who comes into your heirs' lives. How to make sure your kids will handle their inheritance wisely. With our unique subtrust system, you set specific rules for your heirs' access. Even tie it to milestones like college graduation. And by the way, they're safeguarded from frivolous spending or toxic influences. Afraid your life savings might vanish after you're gone? You'll learn how to stop predators, in-laws, and outlaws from siphoning off your legacy. So every dollar goes to the people who matter, not to opportunists with hidden agendas. Whether you need to use all of these tools or only a few, I'm sure you'll find something in this presentation that you can use for your family's future. Let's get started. So we talked about how hard you worked for everything you have. The question is it going to go to the people you want it to? Or is it going to go to in-laws, outlaws, and everyone's least favorite family member, Uncle Sam? What happens to inheritance comes down to whether your family can solve 5 problems we're going to cover here. The 5 problems are: 1. Inheriting a tax bill. 2. Empty parachutes. 3. Predators, in-laws, and outlaws. 4. Special protections for special people. 5. Fighting time. Every family we run into has at least one of these. Some have several, and others have all 5. I want to tell you the story of a client that went to one of our partner offices in 2022 to explain these 5 problems. This client came to us for help with fixing a trust that was set up by a local attorney for his parents who were very well off. He was the oldest of 3 children and took care of it on behalf of his siblings because he was named as the trustee. His father had passed away in 2011, and his mother lived for 11 years after that until 2022. I can't share his real name because of attorney-client privilege, but for this presentation, we'll call him Colton. Let's start with the first problem, inheriting a tax bill. The biggest chunk of the estate left to Colton and his siblings was the remainder of his father's retirement account. There was just over $300,000 left to the 3 of them, so just about $100,000 each. Sounds like a great inheritance, right? Well, not quite. There was a big change in the tax code recently. You might remember news back in 2020 about the Secure Act 2.0 being passed. It is a huge bill, about 2,000 pages long, and we've read it so you don't have to. On paper, it's designed to help people stretch their retirement accounts. And they did. They raised the age you had to take distributions from 70 to 72. But hidden within that 2,000-page bill was a sneaky provision that allowed the government to make more money on taxes from just about everybody else. So since that bill passed on December 20th, 2019, the new rule is everyone inheriting a retirement account has to take all the money out within 10 years. So let me go through how this affected Colton and his siblings. Colton was 45 in 2022. He's going to have to take that money out between 45 and 55. Colton was doing pretty well in his career as the VP of a software company, and because of that, the distributions put him in the highest tax bracket. So out of the $100,000 he inherited, he's going to pay $37,000 to the federal government. And I'm just talking about federal taxes. He still has to deal with state and municipal. Just like that, close to half of his inheritance is gone to taxes, our first problem. And the same for his brother and sister. This is something we see all the time because the majority of baby boomers that do well for themselves keep money in retirement accounts like this. 99% of the trusts written before 2020 offer no protection against this. And it's a ticking time bomb for the people who think they're protected. The amount of money that is going to be raised by the government as a consequence of this new law is mind-boggling. But anyway, let's get to the next problem. Colton's parents used what was called a joint trust, so his mom got everything when Dad passed away. Colton didn't actually get his hands on the trust binder until 2022 when Mom died. He didn't know there was any issue until he went to the bank with the trust in hand. He walked up to the window to take out some money from her checking account to cover the funeral home deposit, about $10,000. The teller had to call in her manager, but when he got there, he told Colton that he had no access to the bank account. It was in his mom's name instead of the trust. He would have to go to the courthouse to get it taken care of. Colton had to put the funeral expenses on his credit card and hire an attorney to help him with the probate. Unfortunately, the lawyer who had set up the trust had died, so he wasn't able to help. The probate took 18 months to settle, and when all was said and done, the inheritance had lost $50,000 to attorney fees. And that leads us to our second problem, what we call an empty parachute. When it comes time to actually use a trust, for example, it's like jumping out of a plane. You can't go back once the person passes away. Whatever you have is what you have. When everything is done right, the parachute deploys. The plan goes on the way it was planned. Everyone gets what they were left with and makes a safe landing. But more often than not, When the trustee pulls the ripcord, they realize the parachute wasn't packed at all, and now they're plummeting to the ground. Now, you probably thought that getting a will or an estate plan was enough, but there are a lot of ways it can become an empty parachute. I'm going to talk about the one that's probably the most relevant to you, and that's not funding a trust. If you own your home, have retirement accounts, or any significant savings, your family will save a lot of money and headache with a trust as opposed to a will. But the challenge with a trust is you have to put things into the trust in order for it to work. The legal term for this is funding the trust. Funding means retitling your investment accounts, your bank accounts, any property that has a piece of property attached to it like a car, and even the deed to the house into the trust. You own the trust, but the trust owns that stuff now. If you skip this step, the trust doesn't work. It's an awesome bag with no parachute in it. And that's what happened to Colton. This might sound like a horror story, but the truth is, half of the trusts we review were never funded in the first place, and over 80% of the trusts don't reflect major assets like houses that were never updated since the trust was originally created. People are blown away when we tell them this. We've seen people who paid north of $10,000 for an estate plan from big law firms that are useless because they never ended up being funded. Now I have to share a dirty secret about the legal industry. Your average hometown attorney doesn't know about this, doesn't want the liability, or doesn't have the staff to do it. It's a huge pain in the butt to get trusts taken care of, and it's different for every bank, 401k plan, and county. Even if your hometown attorney knows how important this is, they most likely put it on you, the client, to take care of with zero knowledge of the process, which most people do incorrectly or never do at all, which leads them to an empty parachute for their family when the time comes and them being in a probate court like Colton. Remember when I mentioned the $300,000 that was left to Colton and his brother and sister? That number is a fraction of what it was supposed to be. His father was a real estate developer and had saved diligently across his life, which would have left his children and grandchildren set for life. But the lion's share of that money ended up going up in smoke in the 10 years after he passed away. See, Colton's mother was a kind woman, and after mourning the loss of her husband, she found herself very lonely. She ended up in a relationship with her tennis coach Blake 4 years after Colton's father passed away. Blake never did well financially, so he ended up moving in shortly after they started dating, and before long he started spending her money like he was the one who made it. They started traveling: Wimbledon, the Australian Open, France. They stayed at the finest hotels for weeks at a time and were able to stay because he quit coaching tennis. Colton wasn't about to stop his mother from having a good time, but after she passed away, he found out Blake had also convinced her to help out his children from a prior marriage with getting through college and helping them pay bills. This is one example of how a fortune can evaporate by going to the wrong people. Blake is what we refer to as a predator, and if you've seen money change hands as often as we do, you'd know that they always seem to come out of the woodwork. In this particular case, the predator happened to target the surviving spouse at the expense of the children, but we see this happen at all levels. Heirs end up with a deadbeat boyfriend who needs to get married all of a sudden and leaves with half a year later. Grandchildren end up as the cool kid on campus when the money comes in and end up bankrolling their friend's trip to Vegas on spring break. It can even be an existing spouse with a drinking problem that you know will be trouble. You get the idea. If you have no estate plan in place, a trust that isn't funded, or a will, you have zero protection from this. Money will go to heirs in lump sum immediately after the probate is settled, or on their 18th birthday if they're a minor, even with a will. Once you name the person, there is zero control over what they, or anyone around them, will do with the money. Speaking of what happens to the money, it's worth mentioning Colton's sister. She ended up getting hit by a drunk driver when she was in her early 30s, and as a result has some permanent brain damage and is in a wheelchair. She had to stop working, but thankfully she was able to qualify for Medicaid and has her medication and treatment covered, about $1,500 per month. Now the issue is, the inheritance she received after everything was said and done ended up kicking her off her benefits. Medicaid has an income and wealth requirement, so if you pass that, you have to take over the costs that are covered. The medication she's taking for pain and neurological symptoms isn't something she can stop, so that $1,500 isn't going away. So out of the $100,000 she inherited, she's burning $18,000 a year on something that was free before she got the money. It will be gone in just over 5 years, and then she will be back on those same benefits. The last problem we're going to cover can lose an estate more money than a predator like Blake, especially when you consider a long enough time frame, and that's missing out on compound interest. Colton's father was managing finances after he retired from real estate development and was doing a good job with it. But that stopped when he passed away in 2012. The market had a pretty good run between 2012 and 2022 when his mom ended up passing. The S&P 500 averaged just over 11% per year. Through the magic of compounding interest, every dollar that stayed in the market in 2012 would be worth $2.84 in 2022. But because the money was sitting in an account, it wasn't compounding the entire time, which means the inheritance could have been almost 3 times as large by the time it got to Colton and his siblings. And that's not to mention inflation, which made those dollars worth 27% less in 2022 than they were in 2012. Now, the thing about predators is that they have to operate in the dark, and it can be tough to move money around. But inflation and missing out on compound interest can be too slow to notice and affect everyone regardless of how much wealth they have. But over time, the amount of money missed out on for an inheritance or lost to inflation can be worse than what even the most bold predator would take. Now, unfortunately for Colton, it was too late to solve these problems. But after going through the probate, we were able to set him up so it would never happen to his family. It's a system attorneys in our network have been refining since 1984 that solves all 5 of the problems we just went over and more. It's called the Lifetime Legacy Trust. The reason we call it that is because it protects your family from just about anything you can throw at it. The structure we use in this trust is the one we use to protect families with a net worth of over $100 million. When that kind of money is on the line, the usual suspects will get extra creative in trying to crack the rules of the trust. So over the years, we've had to find ways to protect money from Uncle Sam, predators like Blake and the like. So if you really want to set your family up, here is how the Lifetime Legacy Trust does it. Let's start at the beginning. What is a trust anyway? A trust is essentially a contract. The Lifetime Legacy Trust instructs where every asset goes, who gets access to it, and under what circumstances they get it. Unlike a will, which is your wishes, the Lifetime Legacy Trust is a legally binding agreement. Wills are instructions for the judge in probate court, and heirs can and do fight against them all the time. A trust, on the other hand, skips probate court entirely. The reason the Lifetime Legacy Trust saves your family from probate and prevents heirs from suing each other 100% of the time is because we go the extra step to fund the Lifetime Legacy Trust for every one of our clients. If you remember from the last section, that means we place every asset, your house, your bank accounts, your retirement accounts, and everything else into the trust for you. Now, just to be clear, you still own all of these things. The Lifetime Legacy Trust is a living trust, which means when you own the trust, you own and control everything in it while you're alive. But if you get incapacitated for whatever reason or eventually pass away, the rules of the Lifetime Legacy Trust kick in exactly the way you set them up. No going to court, no arguing among the heirs or suing each other. It's a legally binding contract. On top of putting everything into the trust when it's formed, we meet with every client yearly to make sure any major changes, new homes, new kids, new grandkids, can be reflected in the plan. And when our clients pass on, we offer a free session to help out whoever they put in charge of the trust for after they're gone. It's always sad to see a client pass on, but the relief we're able to provide the trustees that are able to take over the plan is one of the most satisfying parts of what we do. Moving on. How do we save people from taxes on retirement accounts like 401ks? We have a special way of transferring these accounts using what's called a conduit trust, so the money does not go directly to heirs. Because of that, we're able to avoid the 10-year liquidation penalty provided by the Secure Act. The savings on this can be massive. Taking someone like Colton paying 37% federal tax rate, for example, stretching that out an extra 5 or 10 years until retirement would result in a 10% minimum tax bracket. saving over a quarter of that part of the inheritance. That's just one of the strategies we use for tax savings, but we have an entire tax department if needs get more complex. For example, for people in states with an estate tax limit, we can move assets around 100% legally with gifting, charitable donations, and insurance. We've even set up charities for clients to get their homes and investment properties written off. And beyond the savings your heirs can get from tax strategies, we make sure the money after taxes is growing. We have an entire financial department that specializes in working within the trusts we create specifically. We offer everyone who gets a Lifetime Legacy Trust a 100% free review from our financial team. This is obviously a huge benefit for people who have no plan in place, but many of the people we meet with are able to get much better returns from the strategy that team uses. Finally, let's talk about protecting the vulnerable. Within the Lifetime Legacy Trust, every heir can have their inheritance go into a subtrust of their own. Unlike the trusts we set up for clients, these subtrusts are what's called irrevocable trusts. They aren't in control of the money, it's given according to rules and controlled by a third party you designate. You can set whatever rules you want for these subtrusts, including provisions that prevent tennis coaches or deadbeat friends from taking money out or influencing your heirs. We can use language to limit the amount of money coming up or even tie it to certain outcomes like being in school, employed, or passing a drug test even. These subtrusts make sure they're protected from predators as well and from themselves. The money can be used to further themselves and get to a better place in life, however you define that. Finally, we can protect special needs heirs by having their inheritance go into a separate vehicle. This isn't technically owned by them, so it allows them to stay on benefits. Instead of paying money for medication, they are able to use it as they see fit. The Lifetime Legacy Trust really is an intricate product. We've spent decades building it, and every piece feeds into the last, not only from a legal perspective, but from a tax and financial perspective as well. But the results are incredible. So, if you have any of the 5 problems we spoke about earlier, you might be asking yourself, how do I get a Lifetime Legacy Trust? Before you start Googling, I can save you the time because unfortunately, there is a lot of misinformation on the internet about how estate planning works. Most of the companies putting it out there are selling templates like the blank wills you use to be able to get at Staples. This ranges from ineffective to unlicensed practice of law, but Google isn't taking them down. You can try asking your hometown attorney about doing this for you, but you'll probably be met with a blank stare. Most hometown attorneys are good at the legal side of estate planning, but tend to miss the big picture. There is zero education in law school on the tax, financial, or asset protection side of an estate plan, which means even strong plans will leave legal loopholes that can get exploited by predators. Ultimately, your average hometown attorney can't tell you how to close a loophole they don't know exists. So while a lot of these attorneys mean well, they aren't creating a lifetime legacy trust. But the good news is you don't have to teach your hometown attorney how to build a lifetime legacy trust so your family can be protected. We offer the Lifetime Legacy Trust all over the country, 100% virtual. I'm recording this presentation from our office, but this month we are writing and funding trusts in Georgia, Florida, Michigan, Massachusetts, and 34 other states in total. If you think about most of what you buy today, you're looking to buy the best anywhere. If you want to buy a watch, you buy one from Switzerland. If you want to buy a luxury car, you want to buy one from Germany. If you want a phone, you probably want an iPhone designed in Cupertino, California. And for the first time ever, if you want a lifetime legacy trust, you can get it anywhere you are in the United States. We had to figure out operating virtually during COVID, and after we got used to it, we never went back. We meet with clients over Zoom, we draft documents digitally, and ship hard copies after the fact. We can even do signings online through virtual notary. It's an incredible thing. The reason we are so passionate about doing this is because so much of the country does not have access to any attorneys, let alone attorneys that specialize in an interdisciplinary approach to preserving wealth and legacy. Because we do this virtually, we are able to help people that would not be able to get their legacy secured otherwise. It's a huge help to our elderly and disabled clients who have a hard time coming into an office anyway. And because we don't have to staff offices all over the country, we are able to offer our services at a fraction of the cost that big law firms will charge. Now that you know about the 5 problems that affect 99% of the families in the US, the only question is, what are you going to do about it? If you're someone who wants to leave a legacy for the people you care about in your life, and you're ready for true peace of mind knowing they'll be taken care of according to your wishes no matter what happens. If you're the 1 person out of 3 that will see information like this and take action to set up your family for life, then I have the next step for you that's going to protect your assets, protect your heirs, and set them up for life without leaving them open to any loopholes. If you see the link on your screen here, you can book a link with someone on our team. Here's how the process works once you click that. First, we'll ask you some basic questions about your situation, your assets, who you want them to go to, and anything you've done so far to get protected. If you're all set with what you've done, we'll be the first to tell you. Then you'll book a call with one of our trust executives. This will be a deeper dive into your goals, and you'll actually be able to design where you want things to go based on what you have. If it makes sense to move forward from there, you can get started with next steps. We're able to design, draft, proof, and fund a trust within 4 meetings, which takes most of our clients less than 4 weeks. Of course, it can be longer if you go on vacation, but this gets you protected right away. And like I mentioned earlier, we stay in touch for life. We have annual reviews built into our packages to make sure you stay up to date. I'll leave that link up while we get to Q&A. All right, let's get started. Here's our first question. I have a trust through an attorney I got set up with by my employer. Will that protect my family? Okay, really good question. I'm going to give you the classic attorney answer and say, it depends. Generally speaking, employer sponsorship plans are very high volume. It's a great way to get a lot of experience as an attorney just starting out. But in general, the reason you're able to get a good deal on plans like this is because there isn't a lot of work that goes into them. The real question to ask is, do you think the CEO of the company is using the same law firm that's on the legal access plan? I can tell you they probably aren't, because I have friends that work in big business firms. They will often set up owners, executives, board members, etc., upwards of $10,000 for the plans they do for them. And those still don't do what a lifetime legacy trust does. Okay, second question. I'm not a millionaire. Do I need a lifetime legacy trust? That's another great question. So the truth is, while the lifetime legacy trust structure has protected families north of $100 million in net worth, most of our clients are somewhere between $100,000 and $1 million in net worth. Outside of money, there are a lot of reasons you would want a trust instead of having your family go to probate for a will. For example, a house. Let's say you want to keep your home in the family for generations to come. If it's passed to someone through probate or a will, they can put it up for sale the minute the deed is put in their name. Or if you want to leave it to child A and child B decides that's unfair, now you have your kids suing each other. So there are a lot of reasons that someone with even just a house would want a trust. I will tell you this, if you don't need a lifetime legacy trust, our team will be the first to let you know. We had a client who came in the other day who needed a trust for his mother and was going to pay for it. But it turns out that she only needed a will. He was able to save money and she was able to get what she needed. All right, so unfortunately we are getting short on time, so that will be it for questions. If your question wasn't answered, please keep an eye on your phone. Someone from our office will be giving you a call. So if you're still on this presentation, that means you've been getting good information. But the last thing I want to close out with is the importance of acting on that information. You probably feel empowered right now because we've shared a lot of information. You've gained a lot of knowledge. But to quote Napoleon Hill, knowledge is only potential power. It becomes power only when and if it is organized into definite plans of action and directed to a definite end. Right now, you have the choice to take this knowledge and put it into a definite plan of action. That link you see below you is one of them. But if it isn't with us, I implore you to do something about your family now that you've seen this material. You're going to receive an email in the inbox you used to sign up for this with a checklist of what you need to get answered by any plan you decide to move forward. Remember, missing any of these pillars will leave loopholes in your estate plan and leave your family open to predators and infighting, but the worst potential outcome is doing nothing. If you want to see what this looks like, go on YouTube and search probate court live stream in the search bar. Every day in every county court, there are families going through probate. And the worst part is every one of them heard that they needed to get their affairs in order at one point or another. Some of them watched a presentation like you're watching right now. But instead of taking action, they told themselves, I'll get to it later. Let me tell you right now, I'll get to it later is the path to probate court. And you can go to any courthouse in the country or even go online to see everyone who lost that bet. So the big question for you is, what's the story going to be for your family? Is it going to be like Colton's story, where a generation was robbed of its wealth by predators, taxes, and bad decisions? The 2 out of 3 American families that are held up open to infighting and having their affairs published in the public record for creditors? Or are you going to be 1 out of the 3 people in this country that loves their family enough to invest the time into securing their future now? When you do it right, you only have to do it once, and your family or loved ones will be set up forever.